The first time Charles Whitmore saw Judge Leonard Hayes, he thought, easy target. The first time Judge Hayes saw Charles Whitmore, he thought, another one of them. Neither man knew they were about to burn their lives down in the same courtroom. Charles was the kind of attorney whose reputation slithered into the room before he did. Perfectly pressed suit, watch worth more than most people's cars, and a smirk that made juries feel like they'd been tricked before they'd even spoken. For 2 decades, he'd built a career on technical loopholes, whispered deals, and, more often than not, playing the race card in reverse twisting prejudice into a weapon. When he caught wind of the Turner versus State case, he saw an opportunity. The defendant was a young black man accused of assaulting a wealthy white banker. On paper, it was already a media storm. But the moment Charles learned the trial would be presided over by Judge Leonard Hayes, a man known for his unapologetic stance against racial injustice, his mind started working overtime. Perfect, he thought. All I have to do is push him until he tips his hand. One slip, one outburst, and I'll have him removed for bias. Case 1. Judge Hayes, on the other hand, had weathered storms far darker than Charles could imagine. Raised in a neighborhood where the police sirens sang more often than church bells, he had fought his way through law school, bar exams, and political minefields with the patience of a man who knew what was at stake. He'd seen lawyers like Whitmore before, men who had venom behind polite smiles and legal jargon. The trial began on a Tuesday morning under a sky heavy with the threat of rain. The courtroom buzzed not just with journalists and onlookers, but with something more volatile. In the gallery, you could feel the divide. Half the room wanted the defendant buried under the prison. The other half saw him as the latest victim of a system stacked against him. Charles leaned into that divide. From the very first objection, he dripped contempt into his voice whenever addressing the judge. Subtle, almost invisible to the untrained ear, "Your Honor stretched just a little too long," questions phrased like accusations. He made a point to mention the judge's background in ways that sounded innocent but were meant to stir suspicion. And he smiled the whole time. Judge Hayes saw it, felt it, but he gave nothing away, no raised eyebrow, no sigh, no hint of irritation, which drove Charles insane. On the third day, Charles made his move. He presented a motion to dismiss based on judicial bias, claiming that Hayes had ruled more favorably for black defendants in prior cases. He had spreadsheets, cherry-picked statistics, even a grainy video clip of the judge at a community rally years ago, talking about fighting systemic injustice. The gallery erupted, half in applause, half in outrage. Hayes calmly denied the motion. "Mr. Whitmore, I'll remind you that this court is not the place for conspiracy theories," he said evenly. "Proceed with your case." But Charles wasn't done. He'd planted the seed in the public's mind, and now he watered it daily through subtle digs, sly questions to witnesses, and leaks to the press. The headlines turned ugly. "Is Judge Hayes too biased to serve? Activist judge under fire in high-profile trial." By week's end, Hayes was trending on social media for all the wrong reasons. What Charles didn't know, what he couldn't know, was that Hayes had already suspected a setup from the moment the case landed on his docket, and he had quietly begun building something in the background, something that would flip the entire trial and Charles's career inside out. When the rain finally came on the 4th Friday of the trial, it fell in heavy sheets against the tall courtroom windows. It was the day Hayes allowed the prosecution to introduce a new piece of evidence. It wasn't about the defendant. It was about Charles Whitmore. A hush fell over the room as the clerk placed a thick, sealed folder in front of the judge. Hayes flipped it open, his eyes scanning the contents with deliberate slowness before passing it to the bailiff. "Mr. Whitmore," Hayes said, his voice calm but carrying an edge sharp enough to cut glass. "It appears we have reason to believe that you, not this defendant, have tampered with witnesses and falsified evidence in at least 3 prior cases." The color drained from Charles's face. Somewhere in the back of the room, a reporter's pen froze in mid-scribble. The prosecution's lead attorney, a young Latina named Sofia Ramirez, rose from her seat like a soldier ready for battle. "Your Honor, we move for an immediate evidentiary hearing regarding Mr. Whitmore's conduct. We also request his suspension from further participation in this trial." The gallery exploded. Hayes raised a hand, and silence returned, thick and tense. "The court will recess. Mr. Whitmore, you are to remain available for questioning." Charles's smirk was gone. The game had flipped. And for the first time in his career, he wasn't holding the winning cards. The rain didn't let up during recess. Outside, reporters huddled under umbrellas, firing questions at anyone who would listen. Inside, the courtroom felt like a pressure cooker. Conversations buzzed in low, urgent tones. Eyes darted toward Charles like he was already convicted. In the small antechamber behind the bench, Judge Hayes sat with a steaming mug of black coffee, eyes scanning a thick sheaf of papers. The evidence had come from a whistleblower inside Whitmore's own firm, a junior associate who'd been bullied, underpaid, and finally pushed too far. Hayes hadn't asked for it outright, but when the file landed on his desk, he knew exactly how to use it. He remembered something his mentor had once told him: some men dig their own graves. All you have to do is hand them the shovel. When court reconvened, the air was electric. The defendant, Marcus Turner, sat wide-eyed at the defense table, clearly unsure whether this turn of events meant salvation or disaster. His public defender, a wiry man named Kevin Rhodes, leaned in and whispered, "Sit tight. This might be your lucky day." Charles walked back into the courtroom like a man trying to pretend his house wasn't on fire. His tie was looser now, his hair slightly out of place. He avoided eye contact with the jury. Hayes didn't waste time. "Before we resume testimony, the court will hear preliminary statements regarding the motion for an evidentiary hearing into Mr. Whitmore's conduct." Sophia Ramirez stood first. "Your Honor, we have sworn statements from 3 witnesses, 2 former clients, and 1 former paralegal alleging that Mr. Whitmore fabricated affidavits, paid off a witness to change testimony, and destroyed exculpatory evidence in unrelated cases. We also have phone records, bank transfers, and an internal memo from his firm that frankly reads like a blueprint for obstruction of justice." Gasps rippled through the gallery. One man muttered, "Damn," under his breath. Charles finally spoke, his voice a careful blend of indignation and disbelief. "Your Honor, this is a transparent attempt to smear my reputation because I dared to question your impartiality. The timing, Hayes interrupted, is irrelevant if the evidence is credible." Charles's jaw clenched. "With all due respect, Mr. Whitmore," Hayes said sharply, "this is not a debate club. Sit down." A thin vein throbbed at Charles's temple as he lowered himself into his seat. The evidentiary hearing was set for Monday morning, but the trial itself was still in session. Hayes had no intention of letting Whitmore wriggle free before the current case was decided. That meant the next few days would be a high-wire act for everyone involved. As the prosecution called their next witness, a forensic analyst, Charles sat scribbling notes, though it was clear he wasn't listening. His mind was elsewhere, flipping through contingency plans like a gambler trying to beat the odds. That night, Charles's apartment was lit only by the glow of his laptop. Empty Scotch glass on the desk. His phone buzzed a text from an unknown number. "You're finished. Monday will prove it." Charles's hands tightened around the phone until his knuckles whitened. Then another text followed. "You picked the wrong judge." Saturday morning, the newspapers hit the stands with brutal headlines. "Whitmore under fire for alleged evidence tampering. Star attorney faces ethics probe amid racially charged trial." Social media was a feeding frenzy. Clips of Hayes shutting Whitmore down in court had gone viral, with hashtags like Justice for Marcus and Hayes versus Whitmore trending nationwide. But the most damaging blow came from someone Charles had once considered an ally, a retired prosecutor named Alan Reese, who went on record saying he'd suspected Whitmore of shady tactics for years. "If this is true," Reese told a local news station, "he doesn't belong in a courtroom. He belongs in a cell." Charles didn't sleep that night. Monday arrived with the kind of cold, bright sunlight that made the city look sharper than usual. The hearing began promptly at 9 a.m. Sophia wasted no time laying out the case against Charles. She introduced witness after witness. A young black man who'd been coerced into pleading guilty under threat of fabricated evidence. A middle-aged white woman who swore Whitmore had paid her to misremember events in a civil case. And the paralegal, a trembling young woman named Jamie Larkin, who read from her own notes detailing standard firm practices that would make any ethics board blanch. Charles cross-examined each one, but his usual swagger was gone. The more he spoke, the more it sounded like desperation. Hayes watched him carefully, never once letting emotion slip. By midday, the tide was unmistakable. The evidence wasn't just convincing, it was damning. At one point, Jamie Larkin described a specific memo Charles had dictated, instructing staff to find a narrative that paints the black defendant as inherently dangerous. Doesn't matter how so long as the jury believes it. A low, angry murmur swept through the gallery. Charles tried to object. Hayes overruled him without hesitation. Finally, Hayes leaned forward, folding his hands. Mr. Whitmore, the court finds there is substantial evidence of professional misconduct, including but not limited to witness tampering, evidence fabrication, and racially motivated bias in the execution of your duties as counsel. Effective immediately, you are suspended from further participation in this trial. The State Bar will be notified, and a criminal investigation is hereby recommended. The words hung in the air like a verdict. Charles opened his mouth as if to protest, but nothing came out. His eyes darted from the judge to the jury to the gallery, searching for anyone. He found none. 2 security officers approached, not to arrest him, but to escort him from the courtroom. The sight of him leaving shoulders slumped. The once pristine suit now rumpled was enough to make reporters scramble for the door to get the shot. Hayes turned back to the jury. We will proceed with substitute counsel for the defense. Mr. Rhodes, can you continue? Rhodes stood, a faint smile tugging at his lips. Yes, Your Honor. And I suspect this just got a lot easier. Over the next 3 days, the trial shifted dramatically. Without Whitmore's aggressive maneuvers, the prosecution's case began to unravel under cross-examination. Key witnesses wavered. Evidence that had seemed airtight now had holes big enough to drive a truck through. By Friday afternoon, the jury returned a verdict, not guilty. Marcus Turner collapsed into his chair, tears streaming down his face. In the gallery, a small group of supporters erupted into applause. Hayes banged his gavel once, but the sternness in his expression couldn't hide the flicker of satisfaction in his eyes. As Marcus left the courtroom a free man, Hayes remained at the bench, signing final orders. He could hear the reporters outside shouting questions not about the acquitted man, but about the disgraced lawyer who'd tried to bring him down. That evening, as Hayes stepped out of the courthouse, a young journalist intercepted him. Judge Hayes, any comment on Whitmore's suspension? Hayes paused, adjusting his overcoat. Justice, he said, isn't about winning or losing. It's about truth. And sometimes the truth catches up to people faster than they expect. Then he walked into the rain, his silhouette swallowed by the city lights. The days after Marcus Turner's acquittal were a blur of headlines. Not about Marcus. Not even about the trial. All eyes were on Charles Whitmore. Television pundits circled like vultures, picking apart his career. Former clients stepped forward in droves, some with horror stories of intimidation, others with quiet admissions that they'd suspected something shady but hadn't dared speak. On Thursday morning, the New York State Bar officially announced Whitmore's disbarment pending criminal proceedings. By Friday, the Manhattan District Attorney's Office confirmed he was under active investigation for obstruction of justice, fraud, and perjury. For a man who'd spent decades manipulating the press, Whitmore now found himself trapped in their lens, every photo a study in humiliation. Head down, lips pressed tight, bodyguards hustling him into black cars as cameras flashed. Inside a nondescript government office downtown, Assistant District Attorney Carla Bennett spread a series of documents across a conference table. She was Hayes's age, but with a sharper edge, her years in the organized crime unit leaving little room for illusions about human nature. This is bigger than one arrogant lawyer, she told her team. We've got shell companies, offshore accounts, political donations funneled through intermediaries, all tied to trial outcomes. Whitmore wasn't working alone. He was part of a machine. Her lead investigator, Detective Raoul Kim, tapped one folder. We think he had a list. Defendants who were vulnerable, poor, minority, no real legal defense. He'd target those cases, make side deals, sometimes even tank them if it suited his client's interests. Carla nodded grimly, and he thought Hayes would be an easy mark. He couldn't have picked a worse target. Meanwhile, Hayes returned to his usual docket, but the air in his courtroom felt different. The same spectators who once eyed him with suspicion now regarded him with something closer to reverence. One morning, a young law student lingered outside the courtroom doors until Hayes noticed. "Can I help you?" he asked. The student, nervous, clutching a worn legal textbook, said, "I just wanted to say thank you for not backing down. My father was railroaded in a case years ago, Lawyer like Whitmore. Seeing what you did, it meant something. Hayes offered a small, almost embarrassed smile. It wasn't personal. It was justice. But as the student walked away, Hayes felt the weight of the moment. It was personal. Always had been. Whitmore's world, by contrast, was shrinking fast. His penthouse apartment was sold under quiet pressure from creditors. Old friends stopped returning calls. His own firm scrubbed his name from their website. Then came the subpoena. On a cold Tuesday morning, 2 federal agents arrived at his door with a warrant. They seized laptops, phones, and boxes of case files. The press had the story before the elevator doors even closed. That night, alone in a rented condo with peeling paint, Whitmore sat staring at the subpoena like it was written in another language. The arrogance was gone now. What remained was a gnawing, unfamiliar fear. The indictment came 3 weeks later. United States v. Charles Whitmore. Counts: obstruction of justice, wire fraud, conspiracy, civil rights violations. Carla Bennett's team had gone deep: mails, financial records, even encrypted messages from a burner phone Whitmore had thought was untraceable. They showed a pattern of systematically targeting minority defendants, altering evidence, and manipulating juries to favor wealthy clients. The kicker was a set of memos from nearly a decade earlier, in Whitmore's own handwriting, laying out what he called his narrative advantage strategy. If you control the story, you control the verdict. Play the bias. Use it. Make them fear who they already suspect. When those memos leaked to the press, the backlash was immediate and ferocious. Civil rights groups called for sweeping legal reforms. Law schools used the memos as cautionary tales in ethics courses. And Whitmore's name, once spoken with grudging respect in elite circles, became shorthand for corruption. The criminal trial began in early spring. Hayes was not directly involved. Judges could not appear as witnesses in such cases, but his name was invoked often. Reporters replayed the footage of that pivotal moment when Hayes confronted Whitmore in court, the words becoming almost iconic. The timing is irrelevant if the evidence is credible. Inside the federal courthouse, Whitmore's defense team was a skeleton crew of second-tier attorneys. No one wanted to be associated with him now. The prosecution, led by Bennett, laid out the case like a surgeon exposing rot. Methodical, precise, and devastating. Witness after witness described how Whitmore had leveraged racial prejudice like currency, buying convictions and acquittals with equal ease depending on who was paying. Jamie Larkin returned to testify, more confident this time. He told me once, she said on the stand, that the law isn't about truth, it's about what you can make people believe. And people will always believe the worst about someone who looks like they don't belong. The courtroom was silent except for the clicking of reporters' keyboards. Outside, protests gathered daily. Some held signs with Whitmore's face crossed out. Others carried banners demanding systemic reform. The case had become a flashpoint in a national conversation about race and justice, and every step forward in the trial felt like a reckoning. Back in his own chambers, Hayes followed the news with a measured detachment. He'd done his part. Now it was in other hands. But late at night, when the courthouse was quiet, he sometimes wondered how many other Whitmores were still out there, operating in the shadows. Whitmore took the stand in his own defense on the 22nd day of trial. It was a disaster. Gone was the silver-tongued litigator. In his place was a man fraying at the edges, lashing out at the prosecution, painting himself as the victim of a witch hunt. When Bennett asked if he denied writing the narrative advantage memos, he hesitated just long enough for the jury to notice. Those were strategy drafts. Nothing illegal. Bennett's reply was surgical. Mr. Whitmore, racism isn't just illegal when it's overt. It's illegal when it's weaponized to deny citizens their rights under the law, which is exactly what you did. The defense rested the next day, but the damage was done. Verdict day arrived under a sky heavy with clouds. The jury filed in, their faces unreadable. The foreperson stood. On all counts guilty. Whitmore's shoulders sagged. Around the courtroom, quiet applause broke out from the families of those he'd wronged. Bennett didn't smile. She simply closed her folder, the workmanlike satisfaction of a job finished. Sentencing was set for the following month. Whitmore faced the possibility of decades in federal prison. When Hayes heard the news, he was in chambers reviewing a stack of unrelated motions. He allowed himself one deep breath, equal parts relief and grim acknowledgement. Justice had been served. But the system, he knew, was still far from fixed. That evening, as he walked home through the damp spring air, he passed a mural painted on the side of a community center. A black boy holding a set of scales, the words "Justice for All" scrawled above. Hayes stopped, studying it for a long moment before moving on. The sentencing hearing drew a crowd that filled every seat and spilled into the hallway. Reporters had camped outside since dawn, and the plaza in front of the courthouse was alive with chants, drums, and cardboard signs. Inside, the air felt dense, the kind of heaviness that precedes a storm. Whitmore sat at the defense table in an ill-fitting suit, his hair grayer, his face thinner. Months in custody had stripped him of the polished armor he'd worn his entire career. He stared at the tabletop, avoiding the camera's relentless gaze. Judge Raymond Ellis, a stern figure with a reputation for cutting through theatrics, presided over the proceeding. "Mr. Whitmore," he began, "you stand convicted of obstruction of justice, conspiracy, wire fraud, and civil rights violations. Your actions struck at the heart of our legal system. You exploited prejudice for personal gain, and in doing so, you undermined public trust in the rule of law." Ellis paused, letting the words settle. "The court sentences you to 22 years in federal prison, without the possibility of parole." A collective exhale filled the room. Some spectators wept quietly. Others simply nodded. Whitmore didn't react, not a flinch, not a sigh. Only when the marshals took his arms to lead him away did he glance up, eyes scanning the room as if searching for someone who might still believe in him. There was no one. Outside, the crowd erupted when the sentence was announced. Civil rights leaders spoke to the press, framing the verdict as just one step toward dismantling a system that allowed someone like Whitmore to thrive for so long. "Justice is not an endpoint," one speaker said into a cluster of microphones. "It's a practice. And this practice must continue every day, in every courtroom." That evening, Hayes returned to an unusually quiet chambers. His clerk had left a small envelope on his desk. Inside was a handwritten note from Marcus Turner. "Judge Hayes, you didn't just save me. You showed me the system can still work. I don't know what I'll do with my life yet, but I know I'll try to make it count. Thank you." Hayes read it twice, then set it down gently. It wasn't the kind of victory you framed on the wall. It was something quieter, more enduring. Weeks later, Hayes was invited to speak at a community law forum in Harlem. The audience was a mix of law students, public defenders, activists, and neighborhood residents who'd seen too many trials in the wrong way. He stood at the podium without notes. "I'm often asked if justice is blind," he began. "The truth is, it's not. Justice sees everything: your skin, your wealth, your connections. The question is whether the people carrying out justice have the courage to rise above those things." He spoke about the Whitmore case without naming it directly, framing it as a cautionary tale about power without conscience. "We like to think the villains in our system are obvious, but sometimes they're charming. Sometimes they wear expensive suits and smile for the cameras. And sometimes they know the law so well they can twist it into a weapon. Our job, whether we're judges, lawyers, or citizens, is to see through the performance and hold them accountable." When he finished, the applause was long and loud. But Hayes didn't linger in it. He stepped down, shook hands, and left quietly, as he always did. Whitmore began serving his sentence at a medium-security federal facility upstate. The press eventually moved on, but inside those gray walls, his name carried no weight. He was just another inmate in a khaki jumpsuit, his legal mind of little use where the rules were enforced by routine and reinforced steel. Some nights, he would lie awake in his narrow bunk, replaying the trial in his mind. He told himself he'd been set up, that Hayes had had it out for him from the start. But even in the privacy of his own thoughts, the truth gnawed at him. He'd built his empire on other people's suffering, and it had finally collapsed. The last time he saw himself mentioned in the news was a short column buried on page 12, a brief note about an ethics reform bill inspired, in part, by his case. It passed with bipartisan support. His name was there, but not as he'd once imagined. The city moved on. Cases came and went. New scandals replaced old ones in the headlines. But for those who had been in Hayes's courtroom during that fateful trial, the memory lingered. The moment when the power dynamic shifted, when arrogance met its reckoning, when a system so often criticized for bending toward power bent, for once, toward justice. One rainy afternoon, nearly a year after Whitmore's sentencing, Hayes was leaving the courthouse when he saw a familiar face at the security checkpoint. Marcus Turner, dressed neatly in a collared shirt, was handing over a visitor's pass. "Marcus," Hayes said, surprised. "What brings you here?" "I'm clerking for the public defender's office now," Marcus said with a shy smile. "It's different on this side of the table, but it feels right." Hayes studied him for a moment, then nodded. "Good. We need people who understand both sides." Marcus hesitated, then added, "I don't think I'd be here if things had gone differently. So thanks again, Judge." Hayes didn't say you're welcome. Instead, he simply extended his hand. Marcus shook it firmly, then headed toward the elevators. That night, Hayes walked past the mural again, the boy holding the scales, justice for all still bright against the brick. Rainwater streaked down the wall, blurring the paint in places, but the message remained clear. For the first time in a long while, Hayes allowed himself a small, genuine smile. Justice, he knew, was imperfect. It was slow, messy, and often incomplete, but it was worth fighting for every single day. And as long as he wore the robe, he intended to keep fighting. Thank you for listening. If you find it interesting, please like and subscribe to follow the next stories.